33 of 2024.
Appeal dismissed.
Right, my lord.
But I beg to mention one pending second appeal
Hmm.
filed in the year 2014.
Hmm.
Only 30 days delay, my lord. That notice served upon the respondents, my lord.
For continuation of delay.
Yeah, is there, my lord. 30 days only. Because during the pendency of the case, sole respondent expired substitute date.
Okay, all right. When do you want?
Immediate, my lord, Friday or Thursday.
On Monday, 11.
11.
Maybe, Lordship.
Yes.
To mention for listing on IA, Lordship, for deposition of, for direction of payment of rupees 50%, Lordship. On next Monday, Lordship.
May please, your lordship. Your lordship, I beg to mention item number 14 with the consent of the other side, your lordship. Can the matter be taken at 2 p.m. your lordship?
Item number 14.
1/4/14, your lord.
Today.
Today, your lord.
All right.
At 2 p.m.
Ah.
Deeply okay.
Lordship, I beg to mention item number 8, Lordship.
Hmm.
Lordship, the matter may pass over for the day. Lordship, the conducting counsel is out of station due to medical emergency.
How is his condition now?
He's improving, but there are some problems as well, Lordship.
On the pair being made by Mr.
N.A. Mazharbuya.
M.A.I.
N.A. Mazharbuya, Lordship.
M.A. Mazhar Bhuya, learned counsel appearing on behalf of Mr. A.R. Bhuya, learned counsel for the petitioner with concern from the other side. List the matter after
3 weeks.
3 weeks.
I love that, Lordship.
Please, your lordship. So I beg to mention for listing is CRP, lord.
When?
6th of November, lordship.
6.
6.
In which column?
Motion.
Motion.
May I please, your lordship, I beg to mention item number 31. Lordship, we have filed our affidavit. Our affidavit may be called for.
Okay.
Yes, Lord.
Okay.
May I please, your lordship? Lordship, I beg to mention item number 13 on behalf of SK Talukdar.
Item number 13.
Lordship, I'm seeking for adjournment due to personal inconvenience of my senior. The matter may be listed on 7th November.
On the pair being made by Ms. So-and-so, learned counsel appearing on behalf of Mr. S.K. Talukdar, learned counsel for the accused, raises the matter. After
7th November.
7 November.
Lordship, not on 7th, Thursday, on 13th. 13th November.
Highly obliged.
Wait, please, your lordship. Wait, please, your lordship. Lordship, I have filed this FAO along with an IA on Saturday. Lordship, I wanted to, if possible, lordship, it can be taken up tomorrow, lordship.
One case.
One case. Okay.
Highly obliged, lordship.
May I please, Your Lordship? I beg to mention item number 4, Lordship. I may be allowed to withdraw with regard to file appropriate application, Lordship.
Mr. Your good name?
P. Gogoi.
P. Gogoi, learned counsel for the petitioner, submits that he may be permitted to withdraw this petition with a liberty to approach this court again by filing appropriate petition. There is accordingly allowed. This CRP stands disposed of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Lordship.
Wait, please. My lord, the insurance company filed an appeal along with IA, my lord, for condition delay, my lord. And I am the claimant, my lord. I have also filed an open of my lord. And the last case was listed on 2020, my lord. Till the case they have not listed. So let the matter come on 11, my lord.
11. Yes.
May I please, your lordship? I beg to mention an item for listing. It was last listed on 3, 5th, and
When do you want?
6th of this month, 11th.
6.
Under which column?
Admission.
Admission. On 13th, is it okay?
Sir, 6, the matter has been last due for many months, your lordship.
Okay.
Most of us.
May I please, your lordship?
Hmm.
I beg to mention for listing RSL.
When?
8.
8.
So,
No, the one RSA was listed on 28th of October. Lordship was pleased to admit it, and there was a stay petition. So on that day, I could not produce the, my lord, submit the, my lord, the title execution case number.
Hmm.
So Lordship has directed me to obtain the instruction. So I have obtained, my lord. Can it be on 6th, my lord?
Sixth already
What
given.
urgency is there?
My lord,
What urgency is there?
but actually, on that day, I have submitted that revenue personnel has already measured the land.
Hmm.
So that is why, my lord, on 6th or 7th, my lord, can it,
On Monday, 11th.
for orders, my lord,
So many cases, same thing, Lordship, matters may not reach. Okay, on 8th, then.
Okay, we'll try.
On 8th.
oh, Lordship.
May it please your lordship. Lordship, I am paying for listing of a MSc appeal, my lord. Any day of next week, my lord.
On 13th.
Okay.
May I
Obli-
please your Lordship? Lordship, I beg to mention on RFA, filing on 10 July, Lordship.
Hmm.
So kindly Lordship,
When?
8.
Not 8th. On 13th. 8th, Lordship, already so many cases are fixed.
It's a motion matter, Lordship.
Motion matter also. Lot of matters have
That is
already
on
been fixed.
Wednesday, 13th on Wednesday.
Lordship, I beg to mention listing of a matter. Sir, CRP 10/2/29 of 2024,
When?
Friday.
Next Friday?
24 meter, 2024 meter,
This
on 13th.
This Friday, because there was a stay order which was dismissed,
Is still,
but there is urgency.
and on Monday, 11th, Monday.
Lordship, Friday, if it's possible.
Friday. Your matter may not reach on that day because some hearing matters have already been fixed on that day. So let it be on Monday.
On 11th.
Lordship, I'm praying for listing of a CRP on 13th, Lordship.
13th.
My pleasure.
Uh,
In item number 6, I have filed an affidavit, additional affidavit,
hmm.
as per your lordship's order.
Yes.
That may be called for. Yes. Item for motion bail application. Item number 2.
Timing for Martinez legs.
What is this? The case is pending. In the trial court, at what is this? The case is pending. You are not aware of. Okay, after some time.
My lord. Item 31.
I have made reputation.
At 2 p.m. then?
Item
Highly obliged.
for motion. Item number 3.
Lordship, kindly pass over for time being.
Item 4. Oh, sorry, item 5 for motion.
Please.
No, no, I have already filed Wakalatnama. Kindly pass a direction to the petitioner side to furnish copy of petition along with connection.
Where is the prisoner?
Oh. Then
After some time?
Item 6.
All person.
My lord, that's affidavit.
Okay, okay, at 2 p.m. then.
A minute.
Hmm.
Oblige. Item 7.
Pass over.
For admission, item number 9.
দেখে আপু এবার কল করে।
Item 10.
Please, Lordship. Lordship, held a case, my lord, where a suit has been instituted against me for my lord, a realization of certain amount,
Hmm.
and out of which, my lord, a prayer was also made by the other side for attachment of the property which is not connected with the suit, another property. Now, a ex parte order they have obtained, my lord, for attachment of the property which is not connected to the suit in other way.
Hmm.
Now, challenging that, my lord, we have approached before this in our court by way of this revision petition. Initially, being caveator, my lord, the matter was hard in length, and thereafter, my lord, that the proceeding was stayed in respect of the, my lord, injunction, that attachment order.
Hmm.
Now, lordship, the case is ready for hearing. Lordship may, by admitting the same, lordship fix this matter for, my lord, final disposal. The two law points are important, my lord, here. Number one, my lord, in order to invite order 38, my lord, rule 5. Now, what are the basic requirements? Whether it has been complied with or number one. And number two issue that, my lord, if suppose a property which is nowhere connected with the suit in question, my lord, can it be attached, my lord? And third issue is that, my lord, the imminent urgency, my lord. That if suppose there is no such situations reflected in the petition itself, that there is no imminent danger of suppose disposal, prima facie, my lord, then question doesn't arise, my lord, that two property has to be, my lord, that two suit has to be protected by attaching the another property, my lord. These are the three legal core issues which required answered by this honorable court. Lordship, I pray because some judgments are there. Lordship, fix a date for final hearing, lordship, so that this matter can be disposed of.
No, my lord, this has been, the submission has been made with a delay, with a review to delay the matter. First of all, your lordship, we filed an application for attachment before judgment in the suit. In this case, they sold us a government land, projecting it to be a patta land, took from us 1 crore 90 lakhs. So, your lordship, having no alternative, when we were defrauded in the matter, we approached the London Trial Court and we filed an application suit along with an application for attachment before judgment, because the property in question, in respect of which the agreement was entered, is a government land. So, showing the urgency and after considering all the ingredients, the conditional attachment order was passed, which is an ad interim order. Now, this matter was filed a week before, when the matter was fixed before the London Trial Court on 19/7. Just 2 days ahead, they moved the matter and an interim order was passed, considering that the matter will be disposed of at the admission stage. Now, on 19/7, when the matter was fixed before the London Trial Court, your lordship, they appeared and they submitted their written objection as well as written statement. It's a conditional order of attachment, your honor. The only thing, to my humble and respectful submission, being an application under section Article 227, is to see whether the trial court has jurisdiction to pass that order, whether the trial court exercises jurisdiction vested in it. If they can satisfy that the London Trial does not have jurisdiction to pass such an order, then perhaps the revision petition can be allowed and disposed of. So if my learned friend does not have any other, I will just take this on court to the matter, to the proceeding in hand, because it's not just simple, because your lordship, it's a conditional order of attachment, which was operative until the next day. If your lord comes to the,
No, our Buddha part is ready today.
my lord, I am ready, because on last date, they,
Today is the admission column, my lord. Definitely,
No,
my lord,
maybe
Hey, lordship.
after today. Where is the bar?
No, there is no bar, absolutely.
Yes.
But there absolutely no bar. What I'm saying, my lord, lordship fix a date for hearing so that, my lord, we will also get preparation for entire thing. My lord, 2 or 3 law points are there. My lord is correct that if suppose the power has been invoked in right direction, my lord, yes, my lord, there is no interference called for. But if suppose, if satisfied before this honorable court that actually the power which has been called for, my lord, which is otherwise contrary to the records itself, my lord, question doesn't time the order will sustain, my lord. Therefore, my lord, what I pray, my lord, anyway, any time, my lord.
lordship, last date they prayed for an adjournment. I
No, my lord,
did not, I consented to the same. They told me that they will argue the matter today.
Hmm.
That's why, your lordship, I considered on 4th.
Okay, Kobe, how
Yes,
many matters listed? Yes, tomorrow?
Tomorrow, 19 lordship.
19.
But tomorrow, lordship, I will little difficult, my lord. Next week, my lord, Tuesday, my lord, no problem. Final disposal.
Next?
Next week, Tuesday, my lord.
On 12.
Yes, no problem.
On 13th, can it be? Because on 11th, I will be in Kohima, so I'll come late. On 13th, if it can be.
No problem. I don't have it.
On the pair being made by Mr. S. Somalia, learned counsel for the. And also as agreed by learned counsel for the respondent, dismissal is the matter on 13th. Till then, interim order passed earlier shall continue. It is being clarified that no further adjournment will be granted hearings.
Simply obliged.
Item number 11.
May it please, my lord? There is 11.
Yes,
Item 11.
Yes, sir. Yes, wrong. Sorry.
May I please, this matter relating to non-payment of salary, Lordship. Lordship, the petitioner was appointed as step and teacher, Lordship, in the year 1996, Lordship. And thereafter her service was regularized. In the Lordship in Shivsagar district with the plea dates, the petitioner was appointed beyond the budget elected post, Lordship. Her salary was stopped. Then Lordship, petitioner filed an application due to non-payment, non-release of salary from March 2012. Then there is the inquiry, Lordship. Kindly see the relevant portion of the inquiry part, Lordship. What inquiry part, Lordship?
No, Mr. Counsel, the other side is, who is present?
Last August, Lordship, B Talukdar appeared, he
B.
submitted
Talukdar.
that he got the instruction, he will file the affidavit, Lordship. That order was 13/9/24.
Who is there?
Last order, Lordship.
Yes, I have seen it. Wait for some time.
Yes, sir.
In the meantime, you will inform the council.
Yes, sir.
Number 12.
In this case, the respondent number 5 has filed affidavit, but other respondent have not filed affidavit. Madam. The matter relates to sanction of UGC's grants to the College of Koliagar against one post, but two incumbents are serving against Bachelor of Vocational Course
As a,
as a assistant professor in the subject of Bachelor of Vocation, tourism. Both of us are working in the same college, but when the UGC has sanctioned some amount in the name of one, the college authority by its own, without considering my claim, have all amount has been released to the private testimony. This is my grievance. At least I should be given some share of the amount, 29 lakhs. I'm presently serving at only 10,000 rupees. Petitioner and private testimonies nature of appointments are also similar. On contextual basis,
who are the parties?
UGC and college and director of higher education. Respondent number
Kobe, inform the council. You are for
I'm from.
private respondent.
Respondent number 3.
Respondent number 3.
I have seen this petition, Lordship.
Hmm.
As per the UGC guideline, only one professor is allocated, Lordship. He will be entitled. So, Lordship, record is necessary. I will call for the record, Lordship, from the college, Lordship. I will file affidavit, Lordship. From the petition, Lordship, and UGC guidelines, I have seen that, Lordship, only one professor is entitled for the grant, Lordship.
but
How
college
grant has been coming and how much coming and what is the UGC to instruction to the college, Lordship. I will file affidavit, Lordship, in this regard, Lordship. Otherwise, Lordship,
Mr. Sarma, learned counsel for the petitioner. And also heard Mr.
the amount.
D. Mohanto, learned counsel for the respondent number 3. None appears for the remaining respondents. You are for UGC.
UGC affidavit is also not necessary.
Have you filed your
That's okay.
affidavit?
the dear affidavit also necessary.
They are very much necessary.
And Mr. Your good name, please.
From this side.
Learned counsel for the respondent number 4.
4.
And who is for respondent number 1 and 2?
Director of higher education.
Yes, madam, you are for? None appears for the respondent number 1, 2, and 5. Mr. Mohanto, learned counsel for the respondent number 3 submits that he will file an affidavit in opposition and press for granting him some time. Here is accordingly allowed. Leaves the matter after 2 weeks.
Keeps, Lordship, can we please record the keeps, Lordship.
After 3 weeks. So as to enable Mr. Mohanto to file affidavit in opposition.
UGC's affidavit is also necessary.
The learned standing counsel for the respondent number 4 may also file affidavit in opposition if so advised.
I'll give it. I'll give it. But the timing item 5 to do the previous immediately.
What is it?
Timing item 5.
I've already filed my call of my lordship on behalf of all respondents. Kindly pass a direction to the petitioner side to furnish copy of petition and annexure. Matter can be
Okay,
very short.
sir, your good name?
J Das appearing before SP Royal Lordship. The arguing council out of station Lordship.
They does learned counsel for the petitioner. Then Mr.
Orally.
R. Ali, learned counsel for the respondent, Mr. Ali, submits that he has filed his valid number today,
No, lordship, last week.
last week, and that the petitioner may be directed to furnish a copy of this petition to him. Here is accordingly allowed. Mr. Das, learned counsel for the petitioner, shall furnish a copy of the petition to Mr. Ali during the course of the day. Please the matter on
Next week, lordship.
next week. Copy
On 13th,
13th.
Obliged.
timing item 2, the hearing.
Lordship, I apologize, I was not present when the matter.
Okay,
was
no
called.
problem.
Lordship, trial is going on here.
Hmm.
He-
How many witnesses have been
Seven.
examined?
7 has been examined, and it is clear, Lordship, there is a clear violation of section 50 of the NDPS Act. Police witnesses are over, and the person, the informant, who was the SI of the police, who arrested him and searched him in person and recovered that contraband items. It is clear from his evidence, Lordship, he was not informed that he has a right to be searched in front of the magistrate. And that Supreme Court is very much clear. If that is violated, entire
No,
Lordship.
madam, problem is that nothing has been recovered from this present petitioner, right?
No, it has been recovered from this person itself. Was from
No,
this
no,
person.
no,
That is what they say.
This person, Anil
Yes, this
Pegu.
person, yes.
Acha.
Yes. He is the sole accused. And since 2011, 2023, he is under.
Whether the evidence of the IO is with you?
Lordship, IO is yet to be examined. That is what we have come to know. But the main Lordship, the informant who in fact searched him and arrested him, we have his evidence here.
Let the record come then.
Yes, the scanned copy of the Lordship evidence may be called for. Otherwise, we've got the certified copies.
You have certificate
Yes,
copies?
certified copies.
Yes.
Scan copy is required to find it.
Why?
So
Why?
because my lord, violation of section 50s and others was there for it.
No, that will be on the basis of evidence recorded
Certified copies.
and certified copies of those witnesses are with her. Okay, we will fix a short date.
Lordship.
Let a status report come from the trial.
Copies of the
Heard Miss D. Buragamai, learned counsel for the accused, and Mr. Boisho, learned additional PP for the state respondent. This application under section 439 of the Code of Criminal Procedure is preferred by the accused, namely Anil Pegu, who has been languishing in jail in connection with special NDPS case number 28 of 2024 under section 20B, Roman 2 C of the NDPS Act, arising out of Vipuria PS case number 204 of 2023, pending before the Court of Learned Special Judge Lakhimpur. Bargohai, learned counsel for the accused, submits that till date as many as seven
Seven,
witnesses.
seven.
7 witnesses have been examined by the learned trial court. And from the evidence of the witnesses who examined by the learned trial court, it appears that the IO, no, the informant at the time of conducting search has not complied with the provision of section 50 of the NDPS Act. And therefore, it is contended to allow the petition. On the other hand, Mr. Boisho, learned additional PP, submits that scan copy of the record along with the status report may be called for from the Accordingly, it is provided that the registry shall call for the scanned copy of the record along with up-to-date status report, fixing the matter on
On Monday, 11th,
Friday.
8th. So items for hearing under order 41, rule 2 CPC, item number 15. Item 15.
May I please, your lordship? Lord, in this case, my lord, notice, my lord, the usual process has been sent, my lord. And
Without admitting it.
lordship,
Is it not necessary to first admit the appeal and thereafter to issue notice?
lordship. And expiry, my lord, suit was decreed, expiry was the plaintiff, my lord.
Hmm.
Again, the expiry order, my lord, appeal was filed. In the appeal, my lord, entire suit has been dismissed without remanding the case. Without setting aside the expiry order and demanding the matter for fresh trial, entire suit has been dismissed by the appellate court. Page 25, my lord, the trial court order, my lord. And relevant portion, my lord, page 31. 33, my lord.
What is your summation?
My lord, the judgment, my lord, is absolutely perverse, my lord, because, my lord, the original suit was, my lord, decreed expertise. They preferred appeal setting aside the expertise order.
Hmm.
The learned appellate court, my lord, without deciding the issue, my lord, and without claiming any issue, entire suit has been dismissed. Case 33, my lord, trial court order, my lord, first. And impugn order, case 49, my lord, relevant portion.
Impugned judgment is at page number.
Page relevant portion, page 49, my lord. Paragraph 27, my lord.
So learned, first appellate court has dismissed the suit,
Original suit.
original suit. So what wrong with him?
My lord, no issue has been framed, my lord.
By the appellate court?
Lordship.
Whether framing of issue is required by the appellate court?
Because
It appears that some question has been framed. Some
And
point
no
has
evidence
been
of
identified as point for determination.
lordship.
Paragraph number 45. No, page number 45, page number of paragraph number 10.
Whether the learned trial court is justified in dictating the suit and whether the impugned judgment and decree needs interference in this appeal. My lord, if the order of the learned trial court goes, my lord, then it was ex parte order. And matter should be ought to have been remanded, my lord, for fresh trial. Original decree is, my lord, ex parte. So this challenge the ex parte order.
Is there any statutory requirement that the matter has to be remanded to the trial court?
What the silence, my lord, was ex parte, my lord.
Hmm.
Ex parte order was silence, my lord.
But in appeal, both the parties were heard.
But, my lord, there is no evidence on record, my lord, in the trial court. Because it was ex parte, my lord. Even, my lord, defendant did not adduce any evidence. And our evidence were not cross-examined. Therefore, our evidence remain stand, my lord. And as per, my lord, discussion in paragraph 18, even, my lord, appellate court held that we are, my lord, in possession of 25 bighas of land. Paragraph 18, my lord, page 47. This was admitted by the learned appellate court also.
Page number?
Paragraph 18, my lord. Page 47.
What was the pair in the suit
My lord.
before the trial court?
For right, declaration right to interest and position, my lord.
Where is the client? Page number?
Page, my lord. Page 9, my lord. Start from page 8. Here, my lord, page 18.
Heard Mr. R. Ali, learned counsel for the appellant. It's appeal under section 100. The Code of Civil Procedure is directed against the judgment and decree dated 14/6/2022, passed by the learned additional district judge Surat in TA number 4 of 2019. This to be noted here that by the impugned judgment and decree dated so and so, the learned additional district judge Surat has set aside the judgment and decree dated 8/11/2018, passed by the learned civil judge Surat in TS number 59 of 2017, and dismiss the suit of the plaintiff. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and decree dated 14/6/2022, passed by the learned additional district judge Surat in TA number 4 of 2019, and also the judgment and decree dated 4/11/2018, passed by the learned civil judge Surat in TS number 59 of 2017. This second appeal is admitted on the following substantial question of law. Whether, in view of the evidence, of the plaintiff and his exhibit, no, and the exhibit number 19, the learned additional district judge Surat has correctly dismissed the suit of the in absence of any written statement stroke denial of facts by the defendants to the plaintiff. The record indicates that by order dated 8/9/2023, notice has already been issued to the respondents. Office note dated 4/10/2024 indicates that respondent number 18 and 24 have already suffered demise, and notice upon respondent number 36 could not be served. The learned counsel for the appellant shall take a step to implement the legal representative of respondent number 18 and 24 in the appeal, and also take a step upon respondent number 36 by registered post with AD and also by usual process within a week from today. Registrar shall call for the records from the learned courts below, list the matter of the proofs. IA will be considered. Let the other side enter appearance.
If the lordship admitted to divine,
Yes.
then my lord, I may be considered as your lordship admitted the argument.
Let the other side appear.
Item 11.
Take a step upon respondent number 36. Notice could not be served upon him. And two respondents already suffered demise. You have to take a step to implement the legal representative.
I'm sorry, my lord, I was in another. call.
Okay, all right.
My lord, in this case, I pray for further 1 week time, my lord, because I received the instruction, my lord.
Mm.
As per my instruction, my lord, accordingly, after I received the instruction, my lord, I prepare the affidavit, my lord,
Mm.
and send it for vetting, my lord. The government, my lord, after I received the affidavit, my lord, they want some queries from the directorate, my lord. So they, today morning, they communicated me that is 1 week time, my lord, for
Okay, okay.
yeah.
Heard,
If
Mr.
only-
Rajiv Ahmed.
Clear lordship, my current salary may be allowed, lordship, release 15,000.
Wait for 1 week. Letter affidavit come.
Affidavit file, my lord,
Mr.
B Talukdar.
B. Talukdar, Learned Standing Council for the
Immediate
respondent
education.
number 1, 2, and 3. Submits that he has already received the instruction and prepared the affidavit in opposition and sent the same to the government for vetting. And the government put some queries to the department. And as such, Mr. Talukdar contended that he may be granted one week time to file the affidavit in opposition. Pair is accordingly allowed. Let's the matter of it.
On 18th November.
Obliged, my lord.
Item number 16.
With your lordship. Hello, this is a regular second appeal against the reversal. Now plaintiffs are the my lord appellants. The suit was originally decreed, then my lord the first appellate court has reversed that judgment. Now the suit was for declaration of right title and possession over a plot of land and the my lord the building standing thereon. Now, my lord, plaintiff's case, the appellant's case was that, my lord, their predecessor in the interest was the, my lord, the owner of the land. He purchased the land. And the predecessor in the interest of the respondents, my lord, they were brothers. And there is a, my lord, shop in that land, and in the rent was collected by, my lord, the both of them. At some point of time, my lord, the predecessor in interest of the respondents, my lord, he collected the rent himself, and eventually, my lord, he claimed that I am entitled to the rent. So therefore, my lord, this suit was filed. And in the, my lord, written statement, they did not deny the title of the plaintiff. Then, my lord, eventually it was decreed, and the decree your lordship will find at page 35 of the trial court. Judgment is at my lord, page 35. Now the issues, those were framed, which were framed, my lord, those were all decided in favor of the plaintiff after, my lord, the contest. And that has been reversed by the, my lord, trial court, primarily on the ground, my lord. One ground that is taken is that the my lord, original sale deed, which is, my lord, more than 30 years old, that was not produced, only the certified copy of the, my lord, the sale deed by the predecessor interest was produced, and therefore that is not admissible in evidence. But the fact remains that, my lord, along with the certified copy of the sale deed, by which the predecessor in interest of the, my lord, the appellant's plaintiffs purchased the land, the patta was also produced, the original patta was produced. In spite of that, my lord, on that ground, the finding has been reversed. That, my lord, the plaintiffs could not prove the title to the land. But the fact also remains that in the written statement, there was no denial to the title. Now, my lord, we have prepared the substantial questions, although, my lord, several substantial questions have been, my lord. Page 10, your lordship will find, my lord, the substantial questions. In fact, we have confined,
First, tell me, the learned trial court
my lord.
has accepted the sale deed,
Yes, ma'am.
certified copy of the sale deed.
Yes, my lord, as well as the, my lord.
But the original copy could not be produced.
My lord, that is more than 30 years old, my lord.
That was not, that could not be produced.
No,
But
maybe.
the patta was produced, man. Original patta, man, not certified copy. The patta was produced.
But unless you produce the original cell deed, can you entitle to the benefit of 30 years old document?
My lord, the question here is, my lord,
Hmm.
in order to prove the title, which is not disputed, because my lord, primarily, my lord, the issues are to be framed on the basis of the, my lord, the contentious raised by both the parties. The title of the plaintiff was not, my lord, disputed by the defendant. Therefore, that automatically, my lord, that issue is, my lord, in favor of the plaintiffs. If your lordship kindly comes to the, my lord, their written statement. Written statement, your lordship will find at page 29. That was a very evasive, my lord, written statement. The type copy is at page 29. The original, your lordship will find at page 32. This is the written statement. Page 32, paragraph, that is the paragraph reply they have given. Paragraph 1 is denied. As the first agreement was made in between defendant and the proprietor of Messrs. Minus, that is the shop, my lord, late Kishore Mardani in the year 1965 and not as mentioned in 1169. My lord, in 1965, the house was not there. That, my lord, from the evidence on record, I can show that, my lord. So this is, my lord, one denial.
Okay, we admit the appeal. Let notice go at this instance.
My lord, the substantial questions we have, my lord, confined only to two, my lord. Although we have taken many grounds, may I give a copy of that, my lord?
So you have suggested 2 and 3 as the substantial question of law. 2 and 3.
Yes.
Heard Mr. M.K. Sodori, learned senior counsel, assisted by Mr. Ghosh, learned counsel for the appellant. This second appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 24/9/2024 and 21/9.
In fact, my lord, the date has been, 2 dates have been given in the judgment. And also, my lord,
No,
decree.
no, if the judgment is pronounced on 24/9/2024, decree cannot be prepared 3 days back, 3 days before, on 21st.
No, not decree, my lord. He has signed it, the learned judge has signed it on 21/9, but my lord, the date is given as 24/9. Your lordship may kindly see page 57 and 77
When it was pronounced?
on 24th.
Decree dated 24/9/2024.
And in fact, my lord, decree is dated 3/10/2024.
And the decree dated 3/10.
2024, page 78, my lord.
8/10/2024. Passed by the learned additional district judge number 5, Kamrup M. Guwahati.
Entitled
In title appeal number 19 of 2022. It is to be noted here that by the impugned judgment and decree dated so and so, so and so, the learned additional district judge number 5, Kamrup M. Guwahati has allowed the appeal and reversed the judgment and decree dated 19/10/2012 passed by the learned civil judge number 1, Kamrup M. Guwahati in TS number 33 of 2007. Peruse the memo of appeal and the grounds mentioned therein. Also peruse the impugned judgment and decree dated so and so, so and so. This second appeal is admitted on the following substantial question of law. Number 1. Whether the finding of the first appellate court in holding that the appellant struck plaintiffs have failed to prove their title and thus reverse the finding of the trial court in contrary to the evidence on record and contrary to law. Question mark. Number 2, whether certified copy of a cell deed which is more than 30 years old cannot be accepted as evidence in view of section 65 of the Indian Evidence Act as proof of title when the original patta was admitted in evidence. Let notice be issued to the court may also consider framing of further substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks, to be taken by registered post with AD and also by usual process, which I will come to that. Registrar will call for the record from the learned courts below. Please the matter after 4 weeks.
There are two IAs. One is for, my lord, an injunction. What happened, my lord? They are collecting the respondents are collecting the rent.
Let notice go at this process.
Yes, my lord.
Execution case perhaps not filed till now. In court notices.
Item number 17.
Obliged. My lord, your worship may kindly grant status quo in this, because, my lord, there is a possibility.
No, without hearing the other side.
There is a possibility of alienating, my lord, the property.
If any such apprehension arises, you can mention the matter, we will consider it.
That's why, my lord, the injunction petition.
No.
Obliged.
Item 17. May I please?
Yes.
This is a regular second of the lawsuit. Whatever lawsuit the suit was decreed. And the lawsuit decreed against the dead person law, admittedly. And the court discussed and for 16 days delay has been condoned. And he said that the rest of the delay are not condoned, and accordingly, on that ground also lawsuit, that petition is disposed of and the title appeal is dismissed. Title appeal he has not heard. He has heard the only application for condonation of delay and then dismissed. And it's a decree against the dead person law. And he said that it is decree against the dead person, even then there is a delay. So, and he was admitted in hospital. All the papers was there before the court. Even then, lawsuit delay was not condoned. And it's a decree against the dead person. He died during, and in the same compound. Plaintiff and the defendant stay in the same compound. He died 21 in the 2021, decree of the 2023. And in the appeal, there is a specific ground on that lawsuit, and this was not considered, and the only on the point of lawsuit, the delay lawsuit, it was dismissed lawsuit. Appeal is dismissed. And lawsuit, there is a specific ground in the appeal lawsuit. So there is merit on the appeal lawsuit, so lawsuit will admit on the delay lawsuit, there is a decree against a dead person lawsuit.
So where is the substantial question of law on that
Lawsuit is
point?
page 18.
No, on that point.
Yes, that page 18 lawsuit.
Hmm.
Substantial page 19(2). Substantial question number 2 lawsuit. That point lawsuit. It's a nullity lawsuit. If there is a decree against the dead person, it's a nullity lawsuit. It can be challenged at the any time lawsuit,
Hmm.
whenever and wherever.
Okay. Heard Mr. S. Sharma, learned counsel, learned senior counsel assisted by Mr. T.K. Bhuya. Learned counsel for the appellant. The second appeal under section 100 of the CPC is directed against the judgment and decree. Under section 100, I read with order 42, rule 1, and order 41, rule 1 and 2. Of the Code of Civil Procedure. Is prepared against the judgment and decree. It is against the order, not judgment.
Against the order, because appeal lawsuit only the limitation point is decided lawsuit, and the suit is, the appeal is dismissed, and the decree of the appeal is suit is appeal lawsuit. That is
Against
the
the
page
order dated 15/7/2024 passed by the Learned Civil Judge Senior Division South Salmora, Mankasar. It is to be noted here that by the impugned judgment and decree, the impugned order dated so and so, the Learned Civil Judge Senior Division has dismissed the petition number 516 of 2023, filed under section 5 of the Limitation Act in title appeal number 7 of 2023, and thereby dismissed the connected title appeal number 7 of 2023 and affirmed the judgment and decree dated 28/7/2023 passed by the Learned Civil Judge Junior Division Hatsingimari in title suit number 162 of 2016. Peruse the memo of appeal and the grounds mentioned therein, and also the impugned order dated 15/7/2024. This second appeal is admitted on the following substantial question of law. Number 1. Whether the approach of the appellate court in passing the impugned order dated 15/7/2024 is sustainable in law in as much as the decree passed by the learned trial court against a dead man within bracket, the defendant number 3 is a nullity in the eye of law. But some other defendants are also there, except defendant number 3.
I am in possession lawsuit, because the whole thing is against my client lawsuit, dependent number 3, 1 and 3 lawsuit. The other defendant are not concerned, they are the tenant of the.
No,
defendant.
and by the impugn order dated 15/7/2024, the learned appellate court has only dealt with the issue of limitation.
Yes, yes. And lawsuit
And
54,
the appellate court has not gone into that issue.
that issue lawsuit at page 77 lawsuit, that it is, whether he has died or not, it is not concerned lawsuit, page 77, para 40.
Definitely, if you fail to explain the delay,
So that is what she has written.
so
Delay,
then
he was admitted in hospital.
no,
lawsuit.
that's all right. But that issue has not been dealt with by trial court. No, this appellate court
No,
regarding this dead person.
no. There have been knowledge lawsuit in the same compound.
No,
Appellate court has the
no,
knowledge.
Mr. Soma, you try to understand me. The first appellate court in the impugn order had not dealt with the appeal on merit as to whether
But in the petition
the
itself,
finding of
petition
the
itself, which she has given a finding that against the dead person lawsuit at page 77 lawsuit, para 14. While deciding this application under section 5, she has decided that page 77 lawsuit, para 14. The applicant plead that the Samsul Haq suddenly expired, who was used to take steps or the suit thereafter, and applicant number so and so used to take steps on the said and so and so. Petition cannot be justified. The delay as because the Samsul Haq expired in 31/3/2021. It is an admitted position lawsuit before the decree he died lawsuit. And no substitution lawsuit in the same compound.
no, that maybe, but the appellate court has not dealt with the merit
Only
as to
on-
whether a decree can be passed against a dead person or not.
That's true, but she has
Hmm.
decided that also.
No, not decided. That was the plea taken by the appellants. And she has mentioned it in the order.
Section 1 and 2 and 18 or 18 lawsuit, the 1 and 2 but this is the vital point lawsuit, whether a decree can be given against a dead person lawsuit.
No, there is no doubt about it.
It is an admitted position that he died in the year 2021, decrees of 2023.
Okay. This court may also consider framing of any other substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Issue notice to the respondents returnable in 4 weeks, to be taken by registered post with AD and also by usual process within a week from today.
There is an IA lawsuit.
SSL call for the record from the learned courts below. I let notice go at this system.
No, I'm in possession. That may be status quo lawsuit. I'm in
No,
possession.
for granting such kind of relief, let the other side appear.
No, let them appear lawsuit. In paragraph 7 of my IA, I'm continuous possession lawsuit last 40 years lawsuit.
No,
Possession be protected lawsuit. And notice be given.
definitely we will protect you, but it is this is notice
No,
to.
lawsuit, notice be given.
No, they have not filed any execution case. Whether they have filed any execution
No.
case,
No, man.
then
No, man.
Then?
That I will not say that we do it.
if before passing any order in this IA, they made any such attempt or file any such execution case before the trial court, you mentioned the matter, we'll consider it.
that liberty will be given lawsuit. If there is some any execution, then we can file an trace application lawsuit.
No liberty is required. You can mention it,
Lordship,
we will
Lord-
consider it.
Lordship,
I'm good.
I'm grateful.
Item number 18, matters for orders. Item 18,
None appears for the appellant on call. List the matter after 1 week. 14 matters.
item 19,
May I be a lordship?
Yes.
Earlier occasion, the lordship was pleased to direct the respondent, my lord, to file the copy of the affidavit in opposition, which we have received, my lord, accordingly filed the reply, my lord. That copy is not in the record, so lordship was pleased to direct them to keep the copy. Because in absence of that, my lord, all the pagination may remain unpaginated. And it will cause not only, I think, for me, your lordship will find difficulty, my lord, without pagination, my lord. Because one copy is skipped, my lord. Our reply is in the record, madam. It is not. That was on 13/9/24. Lordship was pleased to pass, direct them to keep the copy of the. Oh, sorry. Learned counsel for the response shall file a fresh affidavit before the ST again. So that we can keep the continuity, madam, the presentation. Otherwise, it will cause not difficulty for me, madam, because lordship will find difficulty without presentation. Because that part is skipped, madam.
You are for the petitioner. You are for the petitioner.
Lordship.
Who are the respondents?
Education department and final, so many, madam.
Okay.
For the respond, I'm appearing for the respond number 18, my lord. Most probably the finance department is the Lordship, matter, there was a common affidavit filed, they're saying. At that point of time, the commissioner and secretary was Mr. Pritam Saikia. And currently, my lord, he's not the commissioner and secretary, he's already retired, my lord, and gone. Therefore, my lord, I think they have to implead the new secretary, my lord. They have to file a.
Already implemented that affidavit is available in the content page number 116. They keep the copy and file there.
My lord, the new secretary is Mr. N. Puan. I don't think they have made a party.
No, implement position. Implement to do this. You have filed a reply, madam, copy is in with them, madam, those who are, the comment comes, who is reading the content case of 120/16. That is their headache.
I'm only for 18, my lord. I'm appearing only for the respond number 18. I'm A. Fukan appearing for respond number 18 only. Not for the, my lord, the other respondents. So other respondents, my lord, they have to be appear, my lord. Some time may be given, my lord. In the meantime, my lord, it's a old matter, my lord. I'll get my instructions also, my lord. Come after a long time, my lord.
You are appearing for respondent
Respondent
number
18, my lord.
18.
No, it was filed by Commissioner and Secretary of Education Department.
Who is for education department?
My lord, Mr. Chisti also is there, but my lord, unfortunately, he's unavailable today, my lord. He's due to some personal difficulty. Matter may be fixed, my lord, after some time, after 10 days, my lord, or I'll in the meantime get the instructions, my lord. Till then, my lord, the other parties also will be there, my lord. If I can pray for that, my lord.
Okay.
Some accommodation today.
Heard Mr. M.E. Amel, learned counsel for the petitioners. And also heard Mr. A. Fukan,
Fukan.
learned counsel for the respondent number 18. Mr. Fukan submits that he may be granted 1 week time to obtain necessary instruction in this matter. And here is accordingly allowed. Mr. Amir, learned counsel for the petitioner submits that he has filed a reply to the affidavit in opposition filed by respondent number,
On the respondent. On behalf of
filed by the respondents.
sorry. All the
And the
petitioners.
same is not placed on record. And accordingly, Mr. Ahmed contended that the said reply may be taken on record. Accordingly, it is provided that registrar shall place the said reply on the record on next date, list the matter on
22nd November.
non-case for the rest of the respondents.
22nd November.
Privilege.
Lordship, sorry, I will be excused, Lordship. The affidavit which is asking for the my lord, that is in the contempt case number 120/16. It is still, my lord, pending, my lord. It is very easy to obtain, my lord. The person who is leading from the government side, my lord, who is contempt case number 120/16, copy is with him or in the registry, my lord. So 2 days already gone because of that, my lord.
No, they can obtain it.
Then I'll obtain instruction, madam. I'll ask Mr. Chisti and Mr. R. Majumdar. They are the, my lord,
No, respondent
leading
cannot give
officers.
instruction. Instruction, already they have given instruction, they have filed the reply.
Therefore, my
It is
lord,
in the record.
since their name is there in that case, my lord, so I will request them to kindly look into it. Privilege.
22nd.
Item number 20,
Nice.
item number 20.
Wait, please, your lordships. This case, as per office note, lordship. 29/10/2024, lordship. Steps we have taken earlier, lordship. And there is an order from this court to resend those notices, lordship. These were only sent on 29/10, so await service report, lordship. On respondent number 6, lordship.
Third is R. Soduri, learned counsel for the appellant. Appellants. Office note dated 29/10/2024 indicates that notices were issued to the performer respondent number 6A261 by usual process.
6L, lordship.
6L
Yes.
by usual process on 29/10/2024. To list the matter after 2 weeks,
Lordship.
awaiting service report upon respondent number, performer respondent number 6A26L.
It's your received, lordship, in this case.
Okay.
Oblige.
Item 21.
I'm for the respondent lordships,
Hmm.
but I have filed the IA lordship. I have to go this side. Lordship. Lordship, IA 1719/2019 is restoration of reopen of the original appeal, lordship. There was an memorandum of understanding.
Please to pass an order to file appropriate application before this honorable court for striking out of the performer respondent number 5 months.
Where is that application?
My lord, I have not filed, my lord, that's why I require, my lord, 1 week time, my lord. That's why I'm looking for.
Okay. Heard, Mr.
P.U. Laskar.
Learned counsel for the appellant and Mr.
UP Chaliha, lordship.
UP Soleha, learned counsel for the respondent number
1, 2, 3, 4.
1, 2, 3, 4. Mr. Loskor, learned counsel for the appellant submits that by order dated 23rd September 2024, he was directed to file an appropriate application for striking out the name of performer respondent. But due to some inconvenience, he could not file the said application and price for listing the matter after 1 week. After 1 week, there is accordingly allowed to list the matter after 1 week.
Oblige. 23.
I'm appealing for the respondents, all the respondents.
But where is the appellant?
Appellant side is.
None of this for the appellant on call, however, Mr. S.D. Purkesto, learned counsel for all the respondents present.
LCR has been received, lordship.
Office note dated 28/10/2024 indicates that LCR has already been received. List the matter after 2 weeks.
It may come up for hearing now.
Other side is absent. Mr. Purkesto, learned counsel for the respondent submits that the matter is ready for hearing. Accordingly, it is provided that recessal list the matter for hearing in usual course. In the event of subsequent non-appearance of the appellant, appropriate order shall follow.
24.
Make the lordship. As per office note dated 29/10/2024, it's already examined from both the courts. LCR has received lordship. An unserved notice from 5A to 5C from registered post lordship. And in usual lordship, await service report. So we can wait for some more days, lordship.
Ms. R. Soduri, learned counsel for the appellant, and Mr. Deka, learned counsel for the respondent number.
All except respondent 5, my lord.
Oh,
Five
all the
expired, so-
respondents,
Yes, lordship. Five
except
expired.
respondent number 5. Office note dated 29/10/2024 indicates that notice issued to the respondent number 5A to 5C issued by registered post, returned with a report that address insufficient return to sender. And no service report has been received on the notice issued by usual process on 27/8/2024. Accordingly, it is provided that recessal is the matter after 2 weeks awaiting service report upon respondent number 5A to 5C.
25.
May I please, your lordship? Lordship, as per office note 30 September 2024, steps by registered post is not received by concerned section.
Third, miss, your name,
Miss S. Das.
learned counsel for the appellant. No, this is CRPIO or for the petitioner. Office note dated 30/9/2024 indicates that step has already been taken upon respondent number, upon the respondents, but no service report has been received till date. What to do? You want to take a step again? The learned counsel for the petitioner submits that she will take a fresh step upon the respondents. Fair is accordingly allowed, list the matter after 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today.
26.
May I please, your lordship? The notice is issued upon respondent number 1, 2, 3, 5, 6, and 4. Therefore, lordship, service may be awaited for the respondent number 1 and 2. And lordship, with regards to respondent number 3, 4, 5, and 6, lordship, they may be strike out, lordship, because they have not contested the suit, lordship. 3, 5, 6, and 4. Respondent number
Third, Mr. Your good name?
N. Brahma, lordship.
And Brahma, learned counsel for the applicant. Office note dated 22/10/2024 indicates that notice issued to the respondent number 1, 2, 3, 5, and 6 not returned till date. Learned counsel for the applicant submits that the name of respondent number 3,
4,
5,
5, and 6.
3, 4, 5, and 6 may be struck off from the array of this application as they have not contested the case before the learned trial court. Trial court and appellate court.
Lordship.
Where? Trial court or appellate court?
Lordship
In both the courts.
both the court. Trial court.
Are you sure? They have not
Right.
contested the case before the learned trial court as well as before the first appellate court. In view of the submission of learned counsel for the applicant, this court is inclined to strike off the name of respondent number 3, 4, 5. What about 2?
Lordship, they have contested this one, 1 and 2.
3, 4,
It is
5,
fine.
and 6. At the cost and risks of the learned counsel for the applicant. List the matter after 2 weeks awaiting service report upon respondent number 1 and 2.
The notices were issued only on 14/10 and the office notice of 29/10. Lord, since 1 month has not been,
After 2 weeks,
yes, yes, 1 month is not elapsed.
heard Mr. D. Sodore, learned counsel for the applicant. Office note dated 29/10/2024 indicates that neither ID card nor unserved notice issued to the respondents received by the registry. List the matter after 2 weeks awaiting service report upon the respondent number 1, 1, 1, 2, and 1, 3.
Twenty-eight,
Yeah, please, Your Lordship. Lordship, as in pursuant to your Lordship's direction on 21/10, the justice service has been taken by us as well as by registered post. The justice service was completed on 31/10/24. The affidavit has been filed today, Your Lordship, so it is not on record. So let it come on Friday, it will be there, Your Lordship.
May it please, Your Lordship, my lord. I am for the, my lord, sole respondent, my lord.
And
appeal.
then he has.
Today, I am going to file wakalatnama, my lord. 1 week time may be granted to file objection in IA, my lord.
Okay.
So far, my lord, the service is concerned.
Heard Mr. A. Biswas, learned counsel for the applicant, and Mr.
HP Gwala, my lord.
H.P. Gwala,
My lord.
learned counsel for the respondent. Mr. Gwala submits that he will file his wakalatnama today,
My lord.
and he will file objection in this application and price for listening the matter after 1 week.
My lord.
Here allowed, list the
Next
matter
Monday, Your Lordship.
on
Next Monday.
Get it a detail.
possible.
coming on 18th.
Yes, Your Lordship.
Obliged, my lord.
Obliged.
29,
If I for condemnation of delay, my lord, in preparing the connected LA appeal, my lord, there is a delay of 61 days, my lord. This is no notice may go, my lord.
Madam, you are for all the respondents.
No, Lordship, only FY number 5, Lordship.
Respondent number 5. Heard Mr. H. Gupta, learned counsel for the applicant. And also heard Ms.
PD
Burman,
Burman,
learned senior government advocate.
additional senior government.
Additional senior government advocate for the respondent number 5. This application under section 5 of the limitation act is preferred by the applicant for condemnation of delay of 64 days in preparing connected land acquisition appeal against the judgment and order dated 29/4/2024 passed by the learned district judge Kamrup M. Guwahati in LA with immediate reference case number 5 of 2014. Let notice be issued to the respondents, returnable in 4 weeks. Step upon respondent number 1, 2, 3, and 4 be taken by registered post with ADA and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 5 since Ms. Gorman, learned additional senior government advocate, appears and receive notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Place the matter after 4 weeks.
Item number 30.
Thank you, Mr. Lordship. Lordship, there is in delay 846 days in filing the connected second appeal. Lordship, notice may be issued in the delay.
Pardon, Mr. Your good name?
M. Alam.
M. Alam, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 846 days in preferring connected regular second appeal against the judgment and order dated 28/2/2022 and decree dated 10/3/2022 in title appeal number 2 of 2021. Passed by the learned civil judge Lakhimpur, North Lakhimpur. Let notice be issued to the respondent. Returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Only one respondent is there? Sole respondent. Place the matter after 4 weeks.
Item 32.
Lordship, may please your lordship, the engaged advocate for the petitioner applicant is on leg in court number 16. Kindly may the matter may be passed over for the time being.
Okay, after some time.
Item 33.
Metric. Yeah, Lordship, respondent number 1 died and there is some delay in filing the substitution application. So therefore, 3IA has been filed, one for combination of delay of 125 days, one for substitution, one for setting aside abatement. Notice will go, Lordship.
Heard Mr. S. Dekar, learned counsel for the applicant. And Madam Eva for?
I'm for 6 and 7.
And Madam K. Fukon, learned counsel for the respondent number 6 and 7.
Yes.
This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 125 days in preferring connected application for substitution of legal heirs of the deceased respondent number 1 by setting aside the abatement. Let notice be issued to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 6 and 7 since Ms. K. Fukon, learned counsel, entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. List the matter after 4 weeks.
Instead of 4 weeks, maybe matter fix after 3 weeks. In the meantime, both the parties has settled the dispute in between.
Okay, okay.
3 weeks.
3 weeks.
Always.
IA number 52, 352, no, 352 and 353, same notices.
Same.
Coming item 3.
May it please, your Lordship. Lordship, this is a civil revision petition, Lordship. The issue involved, Lordship, the petitioner, my lord, while filing the, my lord, claim application under section 166 of the MVL, 45 days delay have been occasioned. And the learned trial court, learned MSCT Golaghat, my lord, the member, my lord, rejected my delay condonation application. And accordingly, my lord, my claim application was not registered. So against that, my lord, I have filed this, my lord, civil revision petition. And on the last occasion, Lordship has asked me when I have received the, my lord, accident information report. Here, my lord, the in this case, my lord, the date of accident is on 26/11/2022. And my lord, I have filed the claim before the MSCT tribunal on 11/7/2023. There were 45 delays has been occasioned. And my lord, I have, but my lord, I have received, my lord, the accident information report was, my lord, issued on 30/12/2022. But my lord, then my lord, the in this particular case, my lord, in my against my delay condonation application, my lord, no one has submitted any written objections, my lord. And my lord, they have never challenged that, my lord, the reason which I have explained, my lord, that was not sufficient, my lord. That kind of, my lord, objection were not come from the other sides, my lord. But my lord, the learned trial court, my lord, the learned MSCT tribunal, my lord, they hold that, my lord, 166(3) says, my lord, no application can be filed after 6 months from the date of accident. So considering, mainly considering on that aspect, my lord, my claim was not registered. My lord, regarding, my lord, regarding, my lord, 166(3), my lord, issue has been presently pending before the Honorable Supreme Court, my lord. And my lord, I have found, my lord, 2 judgments from the, my lord, Honorable Karnataka High Court as well as from Madras High Court. My lord, that says, my lord, it's not that, my lord, Section 5 Limitation Act will not come in regard to, my lord, filing of petition under Section 166. And my lord, while, my lord, considering the delay application, my lord, the tribunal is also required to consider Section 159 of the MVA, which says, my lord, the police officer, my lord, who has, my lord, registered the case is bound to forward it before the learned MSCT tribunal, so that accident information report. And on the basis of that accident information report, my lord, the tribunal can suo moto proceed. But my lord,
that is settled principle.
yes, that is the settled principle, my lord. So, my lord, therefore, my lord, the Madras High Court, my lord, has held that, my lord, I just want to place the judgment before your lordship. My lord, the Madras High Court judgment, my lord, in this case, my lord, 159, 160, subsection 4, 160 subsection 4 or 166 subsection 4, that says, my lord, the claims tribunal said treat any report of accident forwarded to it under Section 159 as an application for compensation under this act. So, my lord, page paragraph 31 of the, my lord, Madras High Court judgment, my lord, that says, my lord, the upshot of the discussion is that on registration of an FIR, a claimant is entitled to present the petition without the fear of it being thrown out on the ground of limitation. This would be correct reading of the present legal dispensation in all cases.
That's all right. You tell me now when the FIR was filed.
FIR was filed, my lord.
That information is not with you now.
Lord, that is not.
But my lord, this is was registered on my lord as Golaghat PS case number 342 2022. And my lord, I have filed it, my lord, in my lord 2023, my claim application. So my lord, this is prior to the, my lord, very much prior. my lord.
You tell me when you
Exact
have
date.
filed the FIR.
Exact date, my lord.
Okay, you obtain necessary instruction. We list it on next Monday. On the appear being made by Mr. Dotto, learned counsel for the petitioner, raises a list the matter on next Monday, so as to enable him to obtain necessary instruction in respect of filing out FIR in connection with the accident before the which PS?
Golaghat PS.
Golaghat PS.
Golaghat PS.
Timing item 21.
Sorry, Lordship, I was not there when it was.
Okay, no problem.
Lordship, this I 171919
3333 2024 has been filed for striking of the name of one of the opposite parties under order 1 rule 10(2), as per knowledge, who died without any legal heir. As per last order, this honorable court asked me, means the petitioner side, to substitute the legal heirs, but as per our knowledge, he died issueless. So striking off his name, we have filed his application. Rest are served.
For Lordship, his name may be strike out from the IA civil number 1780 or from regular second appeal. As because in the cause title, it is written as in the above regular second appeal. Regular second appeal has already abated. It was closed, Lordship. So our prayer ought to be
I apply. It'll be typographical mistake, Lordship.
in 1780, Lordship. Yes. The IA civil number 1780 we strike out if she is praying, Lordship. Moreover, Lordship, we are the plaintiffs, and as per our knowledge, Lordship, he is a necessary party.
The dead person.
No, Lordship, he is a secretary who is the secretary of Jahanpur Jame Masjid, Lordship.
This respondent number 7.
Yes, Lordship. And now the
Even after his death also.
no, they are required to substitute, Lordship.
No, if he left behind no
No, Lordship,
legal heirs, then
he is holding a post, Lordship, secretary. Now who is holding that post? He is to be substituted.
In this case, respondent number 6, being the Jame Masjid, they have already taken notice. If your lordship kindly peruses the last order, 17/7/2024, respondent number 6, represented by its secretary, Longai Jame Mosque, Jahanpur, Longai, taken step, notice has been received. Your lordship may peruse the last order, 17/7/2024. And when the second appeal was surviving, right now it is dismissed for non-prosecution. At that time also, this person was by verbal submission before this court was striken off. But as the second appeal is yet to be revived, this application I have filed praying for the same.
okay. Heard miss, your good night.
At their own risk, your lordship may allow hard pair at their own risk.
Yes, your lordship, yes.
It is always at their own risk.
Lordship,
This application is filed by them.
Lordship, that I lordship admit, but he is, as per plain lordship, he is the secretary of
Heard
respondent number.
miss.
S. Dasgupta.
S. Dasgupta, learned counsel for the applicant, and also heard Miss R. Soduri, learned counsel for the respondent.
Opposite party number 1 and 2A.
Opposite party number 1, 2, and 1, 2, and
A, lordship.
1.
In 1780, I have filed my wakalatnama.
1 and 2A. This interlocutor application under Order 1, Rule 10, which indicates 2, read with Section 151 of the Code of Civil Procedure, is prepared by the applicant for striking out the name of respondent. Number 7 from the array of the IA number 1780 of 2023. The learned counsel for the applicant submits that respondent number 7 already suffered demise, leaving behind no legal heirs for substitution. And accordingly, it is contended to allow this IA by striking up the name of the respondent number 7 from the array of the IA number 1780 of 2023. Ms. Chaudhary, learned counsel for the respondent number so and so, submits that she has no objection in the event of allowing this IA, where having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to allow this IA. The name of respondent number 7 is struck off from the array of the IA civil number 1780 of 2021 at the cost and risk of the learned counsel for the applicant.
Lordship has recorded no objection if it is on the lordship risks of their applicant, lordship.
Pardon?
Lordship has recorded that I have no objection.
Yes,
If it is on the risks of the applicant.
already dictated.
Lordship, there are 3 IAs pending. 1781, 1782.
782.
Today,
In 1781,
Today only listed triple,
a date may kindly be fixed for these applications for hearing your lordship. It will be, if your lordship.
no, we cannot pass the order in the other IAs because those are not listed to do.
Yes, your lordship. Those are pending, your lordship.
Okay, recessal, now the recessal is the matter, list the IA number 1782.
1782. 1781
1781.
is for the.
After 1 week? 1 week?
Yes, your lordship.
Apply.
Much obliged.
Timing item 6.
That helpful, right?
Item 6. Wait, please, your lordship.
Yes.
That affidavit is in record, my lord. And page 46, my lord. Article 522, today final objection has been filed by the judgment debtor, a copy thereof has been duly received by the decree holder. Now it is below, my lord, fixing remand for counter objection, if any, final hearing. Next page, my lord. Plaintiffs are duly represented. Decree holder has filed reply to the final objection of the judgment debtor. Heard both sides. 12/8/22 for final hearing. Objection. Next, my lord. 12/8/22. By petition number so and so, judgment debtor is praying to stay the execution of the decree, showing grounds heard both the sides, so and so for necessary order. Thereafter, that stay petition was rejected. Petitioner has come before this honorable court, and that was ultimately decided against us. So final objection has not yet been, my lord, decided.
No, your petition number 298 of 2024 was rejected.
Milord. Which one?
This paragraph, no, page number 40. Order dated 1/8/2024.
Yes, Milord, that is rejected.
Yes.
Therefore, I am before your lordship.
Uh.
What has happened, Milord? In this case,
No, the petition was considered by the trial court, no, executing court.
no. That, my lord, kindly say. That is at page 27. At page 27. So 29, Milord, 29. This was the order. We have appeared before this. Before
You have preferred this petition against the order dated 1/8/2024, right?
No, my lord. Against the order dated 27/5/24. 27/5/24. That order was passed. And in that order, if your lordship come to a page 31, my lord. If your lordship come to a page 31 of that order, that last line, my lord.
Which one order?
Or that order starts from page 29, that is 27/5/24, my lord. And the last line.
Page number 20?
Order starts from page number 29.
Yes.
I have appeared pursuant to order passed in the CRP. Both the sides have appeared. Now, my lord, at last paragraph, last line, my lord, at page 31. In view of the last line, my lord, in view of the order passed by the Honorable Guwahati High Court and judgment thereafter, not raising any objection, I deem it fit to direct to issue writ after proper verification. But already, my lord, final objection has been filed. And against that, they have filed counter. That has not been decided yet, my lord. Therefore, I have filed an application to review the judgment because there is already in existence a petition. That is, my lord, at page 33, that petition was filed. This is my petition. And ground is there, my lord, at page 34. At page 34, that Roman 3, my lord, that the preliminary objection dated so and final objection dated so and so are yet to heard and disposed of before proceeding with the execution of the decree. This ground was taken. And my lord, by order dated 1/8/24, this petition was also rejected. My lord, my objection or the execution of the decree has not been heard yet, my lord.
No. Void order dated 1/8.
Yes, my lord.
The learned executing court has disposed of the petition 1/8/2024.
298/24, that is for review, my lord. That is not the, my lord, objection petition, my lord, which was filed in the 22. That has not been disposed of, my lord. This is still on record, my lord. Because pursuant to order dated 27/5/24, I have filed this application by saying that my objections are yet to be heard. And my final objection is that page, my lord, 99, sorry. At page 15, my lord.
No. After the direction of this court.
Yes.
At paragraph number 12.
Yes.
In the order dated 26/4/2024. Where is the scope for hearing the petition dated so and so, so and so?
Milord, because that was only for stay. Stay of the execution proceeding, not objection, Milord. Kindly come to at page 27 of that order, paragraph 11. In view of the facts and circumstances above note, it is the opinion of this court that the impugned order dated so as does not call for interference in as much as there is a lawful decree which has been passed in favor of the decree holder hearing. Moreover, it is seen so and so, so and so, so and so. Kindly come to it, please. Yes, Milord. Paragraph 5, Milord. Paragraph 5. At page 25.
That is a submission.
Yes, yes, Milord. What was the petition that I am trying to show, Milord? Because this was a petition under Order 21, Rule 29. That is for, Milord, stay of the execution proceeding, Milord. That was the subject matter in this, Milord, revision petition. But that final objection is yet to be heard, Milord, yet to be heard. That was in terms of section 47 of the CPC, Milord. That petition dated 13/5/22, that was in terms of section 47 of CPC. Thereafter, Milord, it will also come to this additional affidavit. At page 47. By petition number 163 of 22 JD has prayed to stay the execution of the decree. That was Milord challenge before this court by that CRB. Not the objection. That objection has yet to be heard.
Maybe, but there is a direction of this court.
Yes, Milord.
So after that direction, where is the scope for?
Direction for proceeding with the year. But that doesn't mean, Milord, in accordance with law. That word is also there, Milord. That in accordance with law. Yes, Milord. In that execution proceeding, I have filed the objection. That objection has to be, Milord, decided. Here in the CRP, only subject matter was regarding whether the proceeding can be stayed or not. Consequently, the interpretation stands dismissed, thereby directing the learned executing to proceed with the decree in accordance with law. In accordance with law, I have filed already an objection under section 47 of CPC. That is to be decided.
Whether you have pointed out that such and such petitions are pending before the court, executing court?
Yes, Milord, that was.
When?
Milord, that was on that day only for.
And where is those petitions?
Milord.
This petition dated 16/10/2012 and 13/5/2022.
Yes, Milord, that I have annexed. That I have annexed. That is at page 50. That is at page 50.
Page number?
Page number 15, 1 5.
And the petition dated 16/10/2012.
That is not in the Milord petition.
Why?
Final is there, Milord. This is the main, Milord. That was only preliminary objection that those were. And this is the final, Milord. That was to be decided, Milord.
And where is the order dated 13/5/2022?
Yes, Milord. My additional affidavit. At page 46. On that day, Milord, final objection was accepted and case was fixed for counter objection. On the next day, they have filed their counter objection, Milord.
So after this order 27/5/2024, whether any writ has been issued?
No, Milord.
No.
No, it-
Then how you were aggrieved?
no, after disposal of the CRP, it was issued, Milord. That is at page. That is at page. Yes, Milord, that is at page 32 of the petition. I deem it fit to directly issue it after proper verification. That is why, Milord.
No. That observation is there, but no writ has been issued.
But direction has been given to issue it.
No, still a writ has not been issued. So how you were aggrieved?
Will the decree holder is to take steps. Thereafter, I have again filed an application that I have already filed an final objection that is yet to be heard. That was also
No,
rejected.
no, the case is also pending for hearing on the petition. number 430 of 2024, dated 1/8/2024, filed by the decree holder.
Yes, my lord. That was rejected
When?
1/8/2024, my lord. That is last line.
No, again, next date has been fixed on 22/8/2024 for hearing on the petition number 430 of 2024. You see page number 40.
Yes, my lord.
Fixed 22/8/2024 for hearing on the petition number 430 of 2024.
My lord, yes, that petition was filed because the petitioner has prayed for time that he will challenge this, my lord, order 1/8/2024. That he has filed an application by stating that he seeks some time because he has to challenge.
So we
that
are
was rejected, my lord.
Mr. Sahu,
My lord.
We are disposing of this petition
Yes.
by directing the learned executing court
Yes.
to dispose of the petition
Yes.
of final objection
Yes.
if the same has not yet been disposed of.
Yes. Yes, my lord. Before issuing any writ, my lord, that is the question. That is there.
Heard Mr. Sahu, learned counsel for the applicant. This application under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, is preferred by the applicant, challenging the correctness of the order dated 1/8/2024, passed in petition number 298 of 2024. Arising out of title execution case number 5 of 2019 and the order dated 27/5/2024 in the execution case number 5 of 2019 by the learned civil judge, Junior Division, Nargotia. Mr. Sahu, learned counsel for the petitioner, submits that the petitioner is the judgment debtor in the title execution case number 5 of 2019 pending before the Court of Learned Civil Judge, Junior Division, Nargotia. And in the said execution case number 5 of 2019, the petitioner as judgment debtor had filed one petition, had filed objection, final objection,
Preliminary as well as final.
preliminary as well as final objection on 16/10/2020, on a preliminary objection on 16/10/2012 and final objection dated 13/5/2022, and the same are yet to be disposed of. But while order dated 27/5/2024, the learned executing court has already formed an opinion that already directed that the writ will be issued after proper verification, and that if the writ is issued by the learned executing court without disposing of the without disposing of the preliminary objection dated 16/10/2012 and the final objection dated 13/5/2022, then the petitioner will be prejudiced, and therefore Mr. Sahu contended to set aside the impugned order dated 27/5/2024 and the order dated 1/8/2024 passed by the learned Civil Judge Junior Division, the Harkotia in execution, title execution case number 5 of 2019. Where having heard the submission of Mr. Sahu, I have carefully gone to the petition and the documents placed on record, and also perused the order dated 1/8/2024 and the order dated 27/5/2024, and also the petition dated 15/6/2024, being petition number 298, preferred by the petitioner before the learned executing court. From the petition dated 15/6/2024, it appears that the petitioner has filed preliminary objection dated 16/10/2012 and the final objection on 13/5/2022 and the same are yet to be heard and disposed of by the learned executing court. In that view of the matter, this court is inclined to dispose of this petition by directing the learned executing court to hear the petitioner if any preliminary objection dated 16/10/2012 and final objection dated 13/5/2022 are yet to be heard and disposed of before issuing rate in the aforementioned execution proceeding. In terms of above, this CRPIO is disposed of, and this motion is this itself. The petitioner shall obtain a certified copy of this order and place the same before the learned executing court within a period of 1 week from today. And immediately thereafter, the learned executing court shall complete the exercise within a period of 1 week from the date of receipt of certified copy of the order of this court.
They have said nothing about my new grounds, Lordship.
What is your new ground?
One of the poetics already released by the Honorable Apex Court, Lordship, on the ground of prolonged intercession and delay in trial, Lordship. Only on periodic ground we have filed this application.
Yes, Mr. Kyle.
I am relying on one judgment, paragraph 11 of this judgment.
Paragraph
11 of this judgment, Honorable Supreme Court, 3 judges bench has passed this order. Here, bail was granted by Karnataka High Court to 3 accused persons. Paragraph 11 is not for mark that particular portion.
So read it so that he can also hear the matter.
Of Bengaluru. I'm reading the paragraph 11.
Yes.
However, the evidence brought before us against Muhammad Afzal, he accused number 2, responding SLP number so and so, subject matter, the second case, NCB case number so and so, who was granted bail, by order dated 8 January 2020, will have to be treated on an entirely different footing. There are specific allegations leveled against the said respondent regarding recovery of substantial commercial quantity of drugs from the rented accommodation occupied by him, pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated 8 January 2022, wherein the only reason that appears to have been waited with the High Court for releasing him in the bail is that the case stands on the same footing as accused number A1, A2, and A3, A4, who has been enlarged on bail by order dated 11th October 2019, 16th September 2019, and 9th September 2019, in connection with second case registered by the department. Now, Lordship, we are of the firm view that accused number A2 cannot seek parity with the aforesaid co-accused, and no such benefit could have been extended to him in view of section 37 of the Act, when he was found to be in conscious possession of commercial quantity of psychotropic substance as contemplated under NDPS. And here in this case, Lordship, may come to page 38, Lordship, of the bail application.
Page
38.
38.
Lordship.
Yes.
Middle Mahendra Singh,
Mm.
present petitioner.
Mm.
Seized 997 bottles of codeine-based cough syrup were recovered from the conscious possession of Mahendra Singh and others. That is from truck number 20.
Mm.
The contraband was seized from conscious possession of the present petitioner. And from Vinod Vezinaria, Lordship, nothing was recovered from him.
But he was the mastermind.
This is my humble submission.
So, what is the principle on which the benefit of this bail can be extended to the accused on the ground of parity?
Lordship, parity cannot be a ground in case of bail, Lordship. There are so many judgments.
Mm.
But other circumstances, Lordship, is to talk to your Lordship to consider.
Mm.
But in case of NDPS, Lordship, this is entirely different from other offenses.
Mm.
I have prepared a.
How it is also a crime, like any other crime?
Yes, Lordship, but the purpose of NDPS is different from other offenses.
Mm.
Because it destroys the fabric of the society.
Mm.
And it is an organized crime.
Mm.
So this is the difference between this crime committed under NDPS Act and the other offenses.
Mm.
Other offenses, Lordship, it doesn't affect the society at large. But NDPS Act, the offense committed under NDPS Act affects the society at large.
That's all right, but you produce the witnesses before the trial court and complete the trial
That
as
is
soon
there,
as possible. Hmm? When he was arrested?
Lordship, he was
Lordship,
arrested.
1/4/2021.
So more than 3 years elapsed.
Yes.
And Lordship, one thing, Vinod Bajrani was arrested on in the month of November, after 7 months from me.
She was absconded at the relevant time.
Maybe,
Lordship,
but
there is a
after 7 months, he was arrested and he was released on bail. He was nearly about 2 years, 3 months. And I am behind the bar more than 3.5 years.
Lordship, another thing, in Satyendra Prasad, until Supreme Court for the first time says that Section 456A of IPC will be applicable in NDPS case also for the first time. And we go by the dictum of 436 capital A, and half of the sentence to be calculated. Here, maximum punishment is 20 years, maximum punishment is 20 years. If you goes by that dictum, then when he's completed 10 years in jail, then he's entitled to a benefit of Section 436A. And this aspect of the matter was never considered any of the order passed by the Honorable Supreme Court.
You go and point it out.
No, Lordship, we will get chance, then definitely we will point out. We will get chance, Lordship.
No, in many cases of NCB, Supreme Court has been granting bail.
Yes, Lordship, that is, but this aspect has not been considered. In case
So
of,
who is responsible for the same? You people are responsible.
definitely,
You point
Lordship.
it out, you submit it before the
Lordship,
Supreme Court.
Except in Mohammed Muslim, no law has been laid down.
Mm.
Only order has been passed of one page or one another page. In case of Mohammed Muslim, elaborate judgment is that we can consider it as a precedent. But in other judgments, Lordship, even in Vinod Vezinaria case, where Lordship nothing has been considered. Only that trial is delayed, so he has been considered. And here is Lordship, I have pointed out judgment of 3 judges bench Here, Supreme Court in paragraph 11, Lordship, I read out to you, Lordship. And regarding expedited trial, Lordship, definitely it is a fundamental right of the accused person. But in case of NDPS, whether this is applicable. Because Lordship, I have prepared one synopsis. And citing all the judgments of Supreme Court, Lordship, allow me, I can place that before your Lordship for consideration.
Not necessary, what to serve the purpose.
Tomorrow, Lordship, I'll. This is my submission.
So except this ground of parity, do you have any other grounds?
Lordship, here he is the only handyman of the track, Lordship, just 21 years boy, Lordship. Just the handyman of that vehicle. Actually, Lordship, he had no knowledge about the contraband which were under a cover, and he was the handyman because a layman, Lordship. So, Lordship,
What is the function of a handyman?
yes, Lordship. Otherwise, Lordship, I am not so, so much married. Only, Lordship, 3.5 years, more than 3.5 years, Lordship. He is behind the bar. And all last publication witness was 6/5/2024. So there is a delay, Lordship, in the trial process, Lordship. The prosecution failed to, Lordship, examine any witness from 6/5/2024. And then, Lordship, Article 21, they make it violated, Lordship, because Lordship, very much aware, Lordship, I have seen this proceeding of this court. The Article 21, there is a fundamental right. It is the spiritual. It is one of the dimension of the fundamental right of the petitioner, Lordship, of the accused. So therefore, Lordship, there is a delay and prolonged incarceration. It appears, Lordship, in this case. So he is entitled to the otherwise.
And who is responsible for the delay? If you want to argue on that point, you have to establish that the other side is responsible for the same.
Today I am not on other points. But today I am not on, especially I am from my beginning of my submission. I am submitting that.
Parity.
Yes, Lordship. On parity, and their objection.
But as pointed out by Mr. Kyle, parity cannot be extended
Lordship.
because of this judgment referred by him.
Yes.
So he read out the relevant portion before you and before me also.
Yes, Lordship.
So how to overcome that?
Yes, overcome the, I am more than 7 months, Lordship, behind the bar, more than the present petitioner, Lordship, Binod Bijrania, one thing. And the fact and circumstances of that case is maybe different, Lordship, otherwise. And this honorable court, the high courts, Lordship, already held that.
No, Mr.
Lordship.
Ahmed, the principle the Supreme Court has enunciated is that whenever there's a commercial quantity of contraband substances were recovered from the position of an accused, he cannot claim parity with other accused.
Yes,
with from whom
yes, Lordship.
Nothing has been recovered.
Yes, Lordship. If the Supreme Court had observed that this petitioner is less involvement in this case and this petitioner is mass involvement in this case, in that circumstances, Lordship, because Supreme Court already held in Binod Bijrania that there is a delay and prolonged incarceration. Definitely this petitioner of the same footing. No other, Lordship, there is no other point. In the judgment of Supreme Court, the order clearly reflects, Lordship, there is a delay in trial and prolonged incarceration. Only that point, and Supreme Court did not discuss any other point that this petitioner is.
Okay. We'll pass the order.
Lordship, one thing, Lordship, I would like to point it out before closing, Lordship. Kindly see, Lordship, the offense report I am denying. The offense report. Yes, in page number 26, Lordship. Paragraph 29.
Yes.
That in his statement of Sri Ramesh Kumar Yadav revealed some valuable information related with the case. As per the statement of Sri Ramesh Kumar Yadav, he knows Ajodhya Pradesh
Prasad, the main prime accused, from February 2020, and he hired the vehicle from Ajodhya Pradesh, Prasad, when Inter India Company Limited put up a demand for to him. Sri Ramesh Kumar Yadav came to know about the seizure when he was unable to contact with the Ajodhya Prasad. From 29/3/2021, Sri Ramesh Kumar Yadav first came to know about the seizure from Vinod Bizarnia, Lordship, the co-accused. In Vinod Bizarnia, the owner of the seized truck number so and so, and then from Bipin, brother-in-law of Ajodhya Prasad, and then he contacted with Hardoy, brother of Ajodhya Prasad, and Hardoy told him that Ajodhya Prasad, Lordship, the prime accused, done this illegal business for monetary benefit, and Ajodhya Prasad have done this job earlier also. Ajodhya Prasad did this job on the direction of Vinod Bizarnia versus Vinod Chaudhary, the owner of the seized vehicle so and so. Vinod Bizarnia versus Vinod Chaudhary is doing this illegal business from a long time. Vinod Bizarnia, Vinod Chaudhary facilitate to conduct this illegal business by providing vehicle to supplier. But his involvement is very much clear from the offense report. And another point also.
No, maybe, but those are based on the statement of other co-accused.
Yes, sir.
In his case.
Yes.
But in your case, these contraband substances were recovered from your conscious possession.
But Supreme Court did not observe that point, that he is not possessor of that contraband.
Maybe, but certainly that aspect was considered by the Supreme Court because you have placed the entire materials before the Supreme Court.
No, Lordship, because otherwise, Lordship, we will face another difficulty, Lordship. Because he is a poor person, Lordship. Lordship, having no sufficient means to go to the Supreme Court to challenge this order. Otherwise, Lordship, he is behind the bar more than 7 months from the co-accused who has been enlarged on bail by the Honorable Apex Court. So, Lordship, on that aspect should be considered. Otherwise, Lordship, on parity, it could be applicable. Because so many cases, Lordship, I have seen also this Honorable Court, also Supreme Court, are granting bail in the LCB cases. And Robi Purkash also, Lordship, it's fundamental right, Lordship. Lordship, only it can be considered, Lordship, otherwise.
We will examine the issue. When was the order? Like
CD. Pending item 7.
Lordship, Lordship, my matter is very simple matter, Lordship. So since such long time, Lordship, matter has been pending, Lordship, and the school has provincialized, Lordship, the LP school, Lordship, in the year of 2013, Lordship. Thereafter, Lordship, the elementary departments withdraw my provincialization, Lordship.
Why?
So due to the lack of the dice code, Lordship. So here, Lordship, clearly defined in school dice code is available, Lordship. So Lordship, kindly see, Lordship, kindly find page number 18, Lordship. With the annex 2, Lordship. Page number 18, Lordship, here clearly defined. The school name is Rajiv Gandhi LP School, Lordship. And the school code is 02053005, Lordship. In the year of academic 2009-2010, Lordship. That part has clearly reflect, Lordship. So, but the concerned department.
Where is the school code?
School is a Ponitpur, Lordship. District of Ponitpur. Revenue block is a Dhikiazuli.
No, Dias code and school code, is it the same, Mr. Talukdar?
My lord. No, my lord. The dice code issued by the Sarva Shiksha SSA, my lord. And before
this school code was issued by
Director of Education.
Director, my lord. My lord, kindly go straightly go to the annexer 8, my lord, page 42. He is challenge the speaking order issued by the mission director, my lord. That is SSA, my lord. So in this
page number
42, my lord. 42.
Yes.
That was issued by the mission director, SSA, my lord. First, his dice code number was cancel, my lord, and so in this case, my lord, elementary education department has no role, my lord, why the dice code has cancelled, my lord? That was told by my lord SSA, my lord. So he is representing SSA, my lord.
My lord, on behalf of B. Gogoi, my lord, pending council SSA, who is on leave in court number 2, my lord, in some medical urgency matter, my lord, admission matter. Tomorrow is the last day of medical admission, my lord. Here, so far as my lord, our instruction, goes, my lord, we'll place our affidavit, my lord. We'll obtain our instructions, my lord.
When?
2 weeks time may be granted, my lord.
No, already several weeks time.
Several occasion, lordship. So last occasion, lordship, that
1 week, my lord.
court is still directed, lordship, the last chance given. 3/5/2024 already given the last chance. Since last long occasion, lordship, been taking time and time, lordship.
2 weeks, my lord, or 1 week, my lord.
And lordship, whatever here in this case, lordship, so the provincialized dated lordship, page number 26, lordship. It's clear defined, lordship, page number 26, dated 13/5/2023, page number 26, lordship. My serial number is just 9, lordship. So here clear defined, lordship, the Rajiv Gandhi Memorial LP School, lordship. Is a 249.
And this order was cancelled by which order? Page number?
Page 42, lordship, it's being ordered, passed by the director, lordship.
No. This order was cancelled.
And withdrawal, lordship, page number 35, lordship. Page number 35, elementary education, lordship, director of elementary. Page number 35, lordship, here we have defined, lordship. So the provincial may read, lordship. The order, lordship. The provincialization order issued by office order memo nang so dated 13/5/2013 in respect of the Rajiv Gandhi LP School is hereby withdrawn due to non-availability of the dice code as per this office record, lordship. So, lordship, the department himself record, lordship, that page. Kindly find now, lordship, page number 18, lordship. Here clear defined, lordship, page number 18. So due to this non-availability of the dice code, so that's why my school has withdrawn my provincial lordship. The page 18 is clearly defined, lordship. In the academic area to year 2009 and 10, lordship. So there is nothing difficult, lordship. The department whimsical and
No, the question is this a dice code of your school?
Yes, so dice code is already recorded, lordship, the department. So here, lordship, the page number 35 says, lordship, the non-availability of the dice code as per the office record, lordship. But the office record is available dice code, lordship. So here, lordship, the department will plan deliberately withdraw our school, lordship.
Deliberately means?
So, lordship, here, lordship, clear defined, lordship.
We place our instructions, my lord. So far as my knowledge goes, my lord, regarding dice code, my lord, we can obtain our instructions. But if it is related to provincialization matter, my lord, it falls under Department of School Education, my lord.
Discrepancy.
He has not challenged the withdrawal order, madam. You kindly go to the prayer, madam, page 9, madam. He only challenged the speaking order passed by the mission director. You may allow 2 weeks time.
Maybe we can mold the relief. This court has the power to mold the relief, though it is not there in the pair portion of the petition.
Lordship, I have each and every document have appended, lordship. And even though, lordship, the representation of submit, lordship. Representation of submit, lordship, the page number 38, lordship. In my prayer, lordship, each and every document I have appended, lordship. Page 38, I have submit representation. And lordship, initially, honorable court also directed, lordship, that in the year of 17/11/2003, lordship. Honorable Justice Nani Tagia, lordship. So here also clear defined, lordship. The direction was given, lordship. Page number 41, lordship. The relevant part is third paragraph, lordship. Case number 41, Lordship, kindly find Lordship. The Honorable Justice, please to Eric Lordship. Case 41, Lordship. Yes, Eric Lordship. Case 41.
No, not necessary.
So here also direction. Yes,
The basis of that direction, the stricken order will come.
So the esteem order I have challenged, Lordship. Lordship, as per the criteria, Lordship, the 2011 wise, Lordship. So, school has established on that way, Lordship, the school has provincialized. So there is no any doubt, Lordship. So the subsequently, department says also non-available of the dice code. So that part is absolutely reflects, Lordship, in the record of the office. So department, Lordship.
Then this time may be granted, my lord.
School has established in the year 1993, Lordship. So, Lordship, the concern of the non-available of the dice code, Lordship. So dice code record is available. So, Lordship,
No, that is not the dice code as reflected in the order, speaking order, page number 42.
so number 181102
Hmm.
05305, Lordship, available from the year of 2020, 2010, 2011, Lordship. So here, Lordship, recorded academic year in the year of 2009, 2010, Lordship. And the next case, Lordship, school report card 2010-11. 2010-11.
Okay, let them file affidavit, we will fix a short date, 1 week time.
So, Lordship, the last chance, Lordship, initial Lordship, the last chance.
Heard Mr. Arsidas, learned counsel for the petitioner, and also heard Mr. B. Talukdar, learned counsel for the respondent number. Talukdar, you are for respondent number.
One,
Respondent number 1.
two,
1, 2,
three.
1, 2, and 3.
APL 4, 4, 5. 4, 5, 6. 1 to 6, my lord.
1 to 6. And
H. Borwa on behalf of P.
and
Gogoi.
Mr. H. Borwa, learned counsel appearing on behalf of Mr.
B. Gogoi.
B. Gogoi, learned standing counsel for the respondent number 7.
7, my lord.
Mr. Borwa, learned counsel appearing on behalf of the standing counsel of respondent number 7 submits that he may be granted 1 week time to file affidavit in opposition in this petition. Here is accordingly allowed. List the matter on
20.
20. It is provided that no further chance will be granted to the respondent number 7 to file their affidavit in opposition.
Yes.
Highly obliged, my lord.
Last chance.
Can we add 9?
Yeah, please, Your Lordship. This matter is regarding pensionary beneficiaries. As per last order, Finance Department was directed to file an affidavit.
Yes, who is for finance department?
So here appear, my lord.
Then who appeared, my lord?
Filed.
Yes, Soliha.
Yes, only here.
Yes, lord. He was in outside.
I may be allowed to call him, my lord.
Pardon?
I may be allowed to call him, my lord.
Call him. Call him now.
My lord.
Okay, wait for some time. Let them come.
I mean, I know 14.
May legal lordship, herein we are the plaintiff's appellant Miller. We filed the suit for declaration of tenancy right over the suit land and for permanent injunction. The facts of the case, the plaintiff father came into the possession over the suit land in the year 1972 by virtue of the oral tenancy agreement entered with the predecessor of the principal defendants Miller. And in 1990, the plaintiff's father died and they remain in possession of the suit land. And in the year 2014, after the death of the predecessor of the principal defendants, the defendant number 1 to 4 threatened them and threatened them to vacate the suit land. Therefore, they filed the suit for declaration of tenancy right over the suit land and for permanent injunction Miller. The defendant and the principal defendant filed their written statement come counter claim. In their is that defendant denied the existence of tenancy agreement either oral or written. Miller. Another plea was taken that in the year 1972, the predecessor of the principal defendant's father was minor, and therefore he cannot enter into any agreement Miller. And third ground is that the predecessor of the defendant was not the sole owner of the suit land. Others co-owner are there. Therefore, he cannot alone enter into the tenancy agreement. And last plea was taken that the plaintiff is a licensee and he was allowed to stay in the suit land in the year 1972 Miller. And both the courts below findings of the learned trial court in regard to issue number 3, 4, and 5 Miller. Issue number 3, 4, and 5, page number 38 of the trial court judgment below. The trial court specifically came to a finding that the father of the principal defendant was a minor in the year 1972. And as per contract act, he was not eligible for entering into any agreement or contract as he was a minor in the year 1972. And predecessor the principal defendant. Second finding was the predecessor the principal defendant was not the owner of the suit land, and therefore he cannot give the suit land on rent without obtaining the annexation from the other co-owners. Issue number 7, the learned trial court came to the finding that plaintiffs were allowed to stay in the suit land as permissive possessor from the year 1972, and therefore the suit is dismissed and counterclaim is declared Miller. Against that. By common judgment Miller. Against that, we have filed an appeal, and the appellate court also came to the same type of findings. Only an additional finding was given that plaintiff never claimed the right title and interest over the suit land by of adverse possession. Therefore, at the appellate stage, the plaintiff cannot claim adverse possession.
So there is concurrent finding of the courts.
Concurrent finding of the fact. So my humble submission before both the court will come to a finding that the plaintiff's predecessor came into the possession of the suit land in the year 1972. And both the court came to that since the predecessor, the defendant was a minor in the year 1972, he cannot enter into any type of agreement under Indian Contract Act Miller. If the plaintiff father was a licensee under the defendants Miller. Now, my humble condition before your lordships that if he is minor, on the basis of the findings of the learned, if he is a minor, he cannot enter into any type of agreement. That if he cannot enter into tenancy agreement, how can he be entered into a licensee agreement? And on the basis of the plaintiff's father came into the possession of the plaintiff over the suit land through an invalid agreement. and as such possession having been continually peaceful and uninterrupted till 2014, which is the prima facie adverse to the real owner from its inception. The plea of adverse possession inherent in the plea of right of tenancy, which was claimed by the plaintiff. Therefore, the pleading is not necessary in this case. I have relied upon the judgment of the Supreme Court, my lord. And since it is an admitted fact, the both the court came to a finding this, the plaintiffs are in possession over the suit land since 1972 with the knowledge of the true owner, and the owner failed to file a suit for recovery of possession and recovery on the end of 12 years from the date of which the defendants over the suit land. The rights of the defendant's title over the suit are extinguished by virtue of Section 27 of the Limitation Act, Miller. I have, Your Lordship, I have given a substantial question of sheet, Miller. So both the courts below are illegally held that I am the licensee and I have relied upon the Supreme Court decision is there, Miller.
What decision?
1951 Supreme Court. Nineteen 51 Supreme Court, I have marked Miller, paragraph number. I have marked Miller, paragraph number 5, Miller.
Of which decision?
1951 Supreme Court, Miller. The sole question, Your Lordship. The sole question for our consideration is whether on the facts of this case, the respondent corporation has succeeded in establishing in itself a right in limitation of the right of government to assess the land in consequence of a specific limit to assessment having been established and preserved. There is no dispute that by reason of the non-compliance with the statutory formalities, the government resolution of 1860 is not an effectual grant passing title in the land to the respondent corporation and is also not an enforceable contract. On the other hand, there is no doubt as to the existence of an intention on the part of the government to make and on the part of the corporation to take a grant of the land in terms of the resolution of 1865, including an undertaking by the government not to charge any. Both the parties acted on the basis of the resolution and the premises in title of the respondent corporation went into possession of the land in question pursuant to the government resolution of 1865 and acting upon the said resolution and the terms contained therein. The respondent corporation and its predecessor entitled spent considerable sums of money in leveling the site and erecting and maintaining the market buildings and have been in possession of the land for over 70 years. What is in the circumstance was the legal position of the respondent corporation and its predecessor entitled in relation to the land in question. They were in possession of the land to which they had no legal title at all. Therefore, the position of the respondent corporation and its predecessor title was that of a person having no legal title, but nevertheless holding possession of the land under color of an invalid grant of the land in perpetuity and free from rent for the purpose of a market. Such possession not being referable to any legal title, it is primarily adverse to the legal title of the government as owner of the land from the very moment of the predecessor and title of the respondent corporation took possession of the land under the invalid grant.
So how this judgment will help you?
Now, Your Lordship, herein also the respondent came into the possession of the by an invalid grant, and the learned court below held and the learned Honorable Supreme Court held. Since he came into the possession of the invalid grant, but his possession for the land for 70 years, with the knowledge of the owner, therefore he is in adverse possession to the suitland mill. Therefore, the plea of adverse possession is inherent in the plea of plea of rights pleaded by the
Mm.
And another question, another judgment is also 1973. So following this decision,
Mm.
paragraph number 16, my lord.
Mm.
There is no material place before us to show that the grant has been made in manner required by law, though as a fact, a grant of the site has been made in favor of the institute. The evidence relied on by special land acquisition judge and the High Court also clearly established the respondent has been in open, continuous and uninterrupted possession and enjoyment of the site for over 60 years. In this respect, the material documentary evidence referred to by the High Court clearly establishes that the respondent has been treated as owner of the site not only by the corporation but also by the government. The possession of the respondent must have been on the basis of grant by the government, which no doubt is invalid in law. As to what exactly is legal effect of such possession has been considered by this court in and collector Bhundi, the earlier decision has been referred. And following this decision, Rajasthan High Court, I have, your lordship, I have given you the paragraph
Okay,
number.
while decision of the Supreme Court is there is no point
This
for hearing
decision-
on
yeah,
the
this-
decision of High
No,
Court.
Rajasthan High Court followed this decision.
Mm. Okay, yes, Mr. Sharma, you were appearing for the respondents.
Yes.
So what is your submission?
My lord, there is no substantial question of law
Mm.
involved in the second appeal.
Mm.
Because the land was taken taken by the predecessor of the defendant
Mm.
sometime in the year 1972.
Mm.
The land measuring 3 kata 7 lesses. And the case of the plaintiff is this. The, the yearly rent of 3 kata 7 lesses is rupees 120. That means 10 rupees per month. They are occupying the land
Mm.
on payment of rupees 120 per year.
Mm.
That was long before. Thereafter, they failed to pay the rent.
Mm.
And without our knowledge, they applied for the construction of sanitary latrine and other things. Thereafter, when the original owner, Durga Prasad,
Mm.
and the others had died, their heirs have filed a suit
Mm.
for asked them to vacate the land.
Mm.
Then they filed a suit
Mm.
for declaration of their possession right and other
Mm.
things. In the suit, we have filed our counterclaim.
Mm.
In our counterclaim, your lordship kindly
No, what happened to that counterclaim?
counterclaim was decreed.
Decreed.
And against that counterclaim,
Mm.
no appeal was filed. That means my decree for ejectment of the plaintiff from the land has been exist till today.
Mm.
Because
Attain finality.
that attained finality. Because there was no appeal
Mm.
against the decree passed in the counterclaim.
Mm.
And my prayer in the counterclaim is this, at page 27.
In respect of the same suit land?
Same suit land.
Mm.
Page 27. The suit of the plaintiff dismissed at first. The counterclaim of the plaintiff be allowed, declaring that the suit is exclusively belonging to the contesting defendants, and no tenancy ever been created by the defendant or their predecessor in favor of the plaintiff or his father. A decree for khas possession in respect of the suit land and premises be passed in favor of the defendants by evicting the plaintiff therefrom. Issue precept to the chairman Q committee for cancel the holding number.
Mm.
These are my prayer, and the learned trial court decreed my counterclaim.
Mm.
When my counterclaim was decreed, they have not preferred any appeal against the decree of the counterclaim.
So there is evidence that they have paid rent to you.
Their statement is there.
Mm.
They paid the rent
Mm.
at the rate of rupees 120 per month, per
Mm.
year.
Mm.
Subsequently,
They defaulted.
Subsequently defaulted. And they defaulted, and they are occupying the land, and there is arduous construction thereon. And when we need the land, we ask them to vacate the land, And thereafter they filed the suit. Suit for decree for permanent possession as per tenancy right in favor of you. During the proceeding of the case, the main defendant forcefully disposes the plaintiff. Decree may be passed, defendant cannot enter into the suit land. Therefore, their main prayer is that decree for permanent possession of the tenancy right. How the tenancy right they will create? They are the tenant of the land.
No, their contention is that the agreement was invalid agreement.
Invalid. That is
But whether it is a question of law or question of fact, because we can admit the second appeal only on the point of question of law. And the question of law should not be ordinary question of law. There must be some substance. Therefore, it is substantial question of law. So, can the substantial question of law suggested by the appellant herein be considered as substantial question of?
That cannot be considered because my lord, your lordship can see exhibit Go. Exhibit Go. It is at page 39, your lordship. Page 39. Page 39. Third paragraph. Third paragraph. Line. Third paragraph. Line 6 from below. Now it can safely be held that the same birth certificate of the exhibit Go. It appears that the Dharmeshwar Sharma was minor in the year 1972. As per the contract act, Dharmeshwar Sharma is not eligible to entering into an agreement for contract who is a minor at the time. Well, that things whether he is minor or he is major, it is now, it has no, now it is not said. Now what happened is this, they are in possession of the land. They are in possession of the land at the rate of rupees 120 per year, 3 kata 7 acres of land. When we ask for the getting the land, they file the suit for permanent possession, and our counterclaim is declared. Whether the exhibit Go is the substantial question of law or not does not arise at this stage. Because Durga Sharma died long ago. Because their possession since 1972. Now it is 2024. That means 24 plus more than 40 years they are occupying the land without paying any rent. Whether the court will with the appeal on the ground of exhibit Go. My submission is that the exhibit Go has nothing to do. Your lordship is to see whether the findings of the both courts below, it is a concurrent finding of fact. The High Court should not interfere. I have a decision, 2 decisions I have taken. Here the Supreme Court held the concurrent finding of facts.
No, there are a lot of judgments that concurrent finding of facts
The High Court
are
should
binding
not-
upon the High Court.
High Court should not interfere. Therefore, this appeal should not be admitted, and it may be rejected at the today itself. As my counterclaim, there is no appeal against the counterclaim. Therefore, my decree for recovery of possession still exists.
Yes, what do you want to say?
Order 41, order 43, rule 33, power of court of appeal. The appellate court, we have filed one appeal before the appellate court, before the first appellate. They did not raise this point before the first appellate court, my lord.
Which one?
Regarding filing of another appeal, my lord.
Not necessary.
And Order 14, Rule 30, the power of Court of Appeal, the appellate court shall have power to pass any decree and make any order which ought to have been
Except-
passed or made, and to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection. And in this regard, Supreme Court 1976 one, the Coxing cases, it was held that para 4, my lord. The second point raised by the appellant was that the respondent did not appeal from the decree of the trial for negativating her claim in the suit for a charge on the property. It was contended that the High Court was wrong in granting a decree for enforcement of the charge, as the decree of the trial court became final so far as the respondent was concerned, as she did not file any appeal therefore. We are unable to accept this contention. Under Order 41, Rule 33 of the Civil Procedure Code, the High Court was competent to pass a decree for the enforcement of the charge in favor of the respondent, notwithstanding the fact that the respondent did not file any appeal from the decree. And Order 41, Rule 33 provides court. Therefore, one composite appeal can be filed. There is no one. And the defense, though the defendant filed counterclaim on the same forms, part of the written statement, the same was not numbered separately and was tried together, and the judgment was commonly passed. And Order 8, Rule 6A to CPC for the which discusses about counterclaim for the purpose of states of counterclaim, and Provision Order 8, Rule 6 of CPC do not envisage passing of a separate decree on the counter. Therefore, right of rejection of a suit and acceptance of a counterclaim, one appeal lies, my lord. This is my humble.
No, appeal lies, that's all right. There is no doubt about it. But appeal can be admitted only on the substantial question of law.
Substantial question, but both the courts below have come to a final.
We cannot examine the facts because first appellate court is the last court in respect of these facts. We are only on law point.
No, my lord, my point is that my claim is declaration of my tenancy right. And both the courts below came to a finding that the predecessor of the defendants cannot enter into any type of agreement since he is a minor. He was a minor at that time. If the findings of the court remain such that he cannot enter into any such type of, how can he be a licensor? It is also wanted that then he cannot be a licensor. He was a minor at that time. There is a question of point of law involved here in my lord. And on the basis of this, my lord, both the courts below held that the plaintiffs are the permissive possessor.
No, if he was minor, how he entered into the agreement?
If he cannot enter into any agreement,
No,
then
you cannot take your take the benefit of your own wrong. You cannot take the benefit of your own wrong. At that time, you ought to have pointed out that he cannot enter into an agreement because he is minor. You have concealed the fact and you have entered into the agreement, and now you are contending that the
no, my lord,
agreement was
this
invalid.
This plea of minor was taken by the defendant, my lord. My case is I claim tenancy under the father of the defendant number 1 to 4. They in their written statement pleaded that the defendant's father was a minor in the year 1970. They proved this fact. And both the courts below came to the finding that predecessor of the defendants was a minor at that time. And therefore, he cannot enter into any type of agreement under Indian Contract Act. If this finding remains, and both the courts below came to a finding that the plaintiffs are the permissive possessor under the father of the defendants. If the father of the defendant is a minor in the year 1970, how can he permit? This is how can you permit to how can you permit the plaintiffs to enter into the possession of the children? So since minor consent is no consent, my lord.
Okay, we'll list the matter for further hearing. We will not admit it today. Third, Ms. Roy, learned counsel for the appellant, and Mr. A.C. Sharma, learned senior counsel, assisted by Mr. learned counsel for the respondent. Leaves the matter on Kabir. Sort that.
On 13th,
13 for further consideration. On the point of
Your lordship.
substantial question of law.
On 15th, my lord,
15,
15th is holiday,
and 18, my lord,
18.
18.
18 Monday, no?
18 Monday,
Monday, I know. 18 and 19, I am too.
then on 20, 20. 20, Wednesday,
21.
21. Okay.
21 Thursday, there will be hearing cases,
Okay, we will take on that day.
21.
21.
Highly up.
I mean, 9.
Mrs. Soliha, you were supposed to file affidavit.
Lordship, here, if I may, Lordship, here, finance department was not made a party. And later on, we were implemented to clarify our stand. So Lordship, here, the department had written to the authorities, the Department of School Education Elementary, because they are the official record keepers of the petitioner. And the petitioner is asking for pensionary benefits. So here, our stand at this stage is, since we had communicated to the Department of School Education on 16th of August, Lordship, asking for the report, because they are the official record keepers of the petitioner. That we have not received yet. Because of which, at this stage, Lordship, it is difficult for the finance department to clarify us.
And that's already you obtained the report.
Yes, Lordship, here that will be subject to the education. I can ask for a updated status, because as per our instruction, it is the administrative department that has to look into these matters. And we have asked for a report, Lordship. So if Lordship may.
No, whether that department is a party in this proceeding.
There is Department of School Education, Lordship, the education department is there, Lordship.
Mr. Talukdar.
That would say he has placed, my lord, that instruction I don't have yet, my lord. So I may be allowed that whether this report has been sent or not to the finance department. I may be allowed 1 week time that in the meantime I will obtain the instruction.
Heard, Miss?
P.
P? Adi?
Naidi. I
Naidi.
already.
Learned counsel for the respondent, no, petitioner. Then Mr. B. Sharma, learned counsel for the respondent number.
B. Talukdar, my lord.
B. Talukdar, learned
Respondent
counsel
number
for the
one.
respondent number.
1, 2, 4, 5. and
1,
6.
2, 4, 5, and 6. And Mr. Soliha, learned counsel for the respondent number 10 and 11.
Subsequently.
Yes, Lordship, we were implemented, Lordship.
10 and 11. And Mr. D.K. Roy, learned counsel for the respondent number. Respondent number 9. Respondent number 9. Mr. Soliha, learned counsel for the respondent number 10 and 11 submits that the finance department has already already called for a report from the Department of School Education, and the same has not yet been received, and therefore already written a letter dated 16 August 2024, number ECF 539202 of 2019. And the report is still awaited. And he will file affidavit before this court as soon as he received the report.
If required, Lordship, affidavit might not be required from our end.
If so required. If so required. Whereas Mr. Learned counsel for the respondents, other respondents submits that he will inquire from the department as to whether such communication has been received or not. And he will respond to the court after 1 week and press for granting him 1 week time. Here is accordingly allowed. Recessal is the matter. On, we'll fix a date.
On 22nd.
22nd. The letter produced before this court by Mr. Soleha shall be part of the record. Any more?
Next is whether item 14 is part heard or.
Which one?
Item 14. under-
Further hearing.
Further hearing.